Three, two, one. Good afternoon and welcome to the special business meeting of the South Carolina Public Service Commission. Today is Wednesday, February 19th, 2025. It's approximately 1 p.m., 2 p.m., 3 p.m. Okay, we'll stop at 3. Before we begin, would you please join me in a moment of silent reflection? Thank you very much. All commissioners are present in the hearing room. Mr. Scarborough, if you would, please proceed.
Good afternoon, Chair Powers, Vice Chair Williams, and Commissioners. Just a reminder, Mr. Chairman, that the next regularly scheduled Commission business meeting is set for Thursday, March 6, 2025 at 1 o'clock p.m.
The next business meeting will be March 6th at 1 p.m.
Thank you. Today we have just 5 items on the agenda. Item number 1 on the agenda is in docket number 2025-11E. This item involves a petition to intervene filed by Michael Weiskopf and authorization for the Chief Clerk of the Commission to schedule the matter for hearing and to adjust the procedural schedule as needed.
Having heard item 1 is presented by Mr. Scarborough, is there a motion? Vice Chair Williams.
Mr. Chair, fellow commissioners, I move that the commission deny the petition to intervene by Mr. Michael Weiskopf to participate as a party of record in this docket. Mr. Weiskopf asserts an interest in Rate 5 of Dominion Energy South Carolina Incorporated. However, he does not demonstrate that the Office of Regulatory Staff, who is charged with maintaining the public interest in all proceedings before the commission, cannot adequately represent his interests as of those of other ratepayers of all classes in this proceeding. The petitioner does not take service from Dominion under Rate 5 and the Solar Choice Rider. Rather, Mr. Weiskopf takes service from Dominion under Rate 8, applicable to net energy metering 2.0 customers, which remains in effect until December 31st, 2025. Regulation 103-825A3 requires that any party, or person filing a petition to intervene in a matter pending before the South Carolina Public Service Commission must set forth clearly and concisely, A, the facts from which the nature of the petitioner's alleged right or interest can be determined, the grounds, paragraph B, the grounds of the proposed intervention, and paragraph C, the position of the petitioner in the proceeding. As such, I move that the commission find the petitioner did not meet his burden to demonstrate an interest or right in this docket and does not have standing to intervene as a party of record. For these reasons, I believe the commission should deny the petition of Mr. Michael Weiskopf to intervene. So moved.
Thank you, Vice Chair Williams. Having heard the motion by Vice Chair Williams, is there any further discussion?
Chair Powers.
Commissioner Williams.
Thank you. I considered supporting Mr. Weiskopf's request because I respect all pro se litigants and the fervor of their interest. However, to do so would be unfair to Mr. Weiskopf because he would not have a forum for expressing his motion. So, Vice Chair Williams, I appreciate your motion and I am going to support it, but I wanted to explain a little bit more about why I've made this determination. Lack of standing or having a personal stake in a case is essential to a fair and productive exchange regarding dockets such as this energy efficiency and demand side management docket. There are regulations and statutes that you mentioned that cover this opportunity. In this case, the utility is asking to change the relevant base tariffs to afford energy efficiency and demand side management program, the cost of which are treated as an add-on or a rider to the base tariff. That is the focus of this docket and no more than that. This docket references Rate 5 and 7, and its focus is on recouping the cost and benefits associated with its EEDSM programs. Mr. Weiskopf is a Rate 8 customer, and in his petition to intervene, he expressed concerns that are focused on the super off-peak and the off-peak hours, which were set in a prior order of this commission. Because the focus of the docket is the continuation of Dominion Energy South Carolina's EE Energy Efficiency and DSM Demand Side Management programs, Mr. Weiskopf's concerns are not germane in this particular docket. The right time to articulate those concerns before this commission would be in a future docket that might involve a rate request associated with Rate 8, or whatever rate Mr. Weiskopf is in at the time, or an avoided cost or a net metering docket. In the meantime, any utility customer can call the Utility Customer Support Office to express concerns and discuss this matter with their utility representative. Thank you.
Thank you, Commissioner Williams. Any further discussion? Hearing none, we'll proceed to a roll call vote. We'll proceed to a voice vote. All those in favor signify by saying aye.
Aye.
Those opposed by no. The ayes have it. The motion carries.
Item number 2 is in docket number 2024-144E. This item involves final disposition of this docket.
Having heard item number 2 is presented by Mr. Scarborough, is there a motion?
Mr. Chair.
Vice Chair Williams.
Mr. Chair, fellow commissioners, I move that the commission find that the settlement agreement offered for commission consideration by Duke Energy Carolinas LLC, Duke Energy Progress LLC, and the Office of Regulatory Staff is in the public interest. Approve the settlement agreement and grant the application of Duke Energy Carolinas LLC and Duke Energy Progress LLC for approval of the 2023 solar and solar paired storage resource procurement program, subject to the terms and conditions of the settlement agreement, all of which is based on the evidence of record presented to the commission in the hearing on this matter. So moved.
Thank you, Vice Chair. Having heard the motion, is there any further discussion?
Mr. Chair,
Vice Chair.
just want to make a couple of comments. As the commissioners know, the Code of Judicial Conduct encourages us to encourage settlements without restricting or limiting any party due process rights. The Commission's own procedures also do so in terms of encouraging settlements when parties can work out their differences before the Commission and bring the agreement to the Commission for consideration. And as the Commissioners know, that's what we have here. I think at least in my view, through the hearing, there may have been some concerns about the settlement, and what makes me feel comfortable accepting the settlement, or a few things that I observed during the hearing, starting with the admission of the settlement agreement into evidence. I'm just going to read from the settlement agreement a couple of subparagraphs. I want to look at section C and go to subparagraph 7H, which reads, the parties agree that in the event the Commission approves the 2023 CPRE program, such approval will be limited to the 2023 CPRE program as presented in this docket and shall not equate to the approval of and shall not be used as dispositive evidence of the following activities and consideration related to the execution of the 2023 CPRE program. And that's number 1, the reasonableness or prudence of any specific project activities related to the 2023 CPR program. Number 2, future recoverability of specific items of costs related to the 2023 CPRE program. And number 3, pre-approval of any rate-making treatment related to the 2023 CPRE program. I want to go on to read subparagraph 7K. It reads, the commissions, and this is again in the settlement agreement, signed on to by the Duke companies and the Office of Regulatory Staff that's responsible for representing and protecting the public interest. So paragraph 7K reads, the commission's review of the 2023 CPRE program does not relieve the companies from any obligation to file Siting Act applications to construct proposed generating facility. Moving on to subparagraph 7L, the Commission's review of the 2023 CPRE program does not alter the general rate-making process pursuant to South Carolina Code Annotated Section 5827-870 and Section 5827-865, accordingly subject to the terms and conditions set forth herein. In the event that the Commission approves the 2023 CPRE program, the parties agree that notwithstanding such approval, the 2023 CPRE program, including but not limited to the associated cost and project activities, is conditioned on and subject to review by the Commission, the Office of Regulatory Staff, and other interested parties for reasonableness and prudency and associated rate-making treatment during future appropriate cost recovery proceedings. The parties further agree that the Office of Regulatory Staff and other interested parties retain discretion to make recommendations concerning the rate-making treatment of the 2023 CPRE program in future appropriate cost recovery proceedings. And as the commissioners know, that settlement agreement was entered into the record for this proceeding during the preliminary matters phase of the hearing before the commission. But not only that, Ms. Smith testified during the hearing that an approval, and I quote, "An approval of the 2023 CPRE program does not relieve the companies from any obligation to file Siting Act applications to construct a proposed generation facility and does not alter the general rate-making process pursuant to South Carolina Code annotated 58-27-870 and 58-27-865. And I'm pulling from page 29 of the transcript, volume 1 of the transcript. I started at line 11 and ended at line 17. And moreover, when Ms. Smith was asked a question regarding what does approving the settlement mean, and I'll just ask the mean for the commission, and I'm reading into the question, mean for the future, subsequent decisions that the commission must make in the future after or if we at the time approve the settlement, which I'm recommending and moving that we do. The question at the time, though, was under Section 7H of the settlement agreement states, and I'm quoting from page 34, volume 1 of the transcript in this matter, and I'm starting at line 8 on page 34. Under Section 7H, and this is a question to Ms. Smith, under Section 7H, settlement agreement states that if the commission approves the 2023 CPRE program, it shall not equate to the approval. It shall not equate to the approval of and shall not be used as dispositive evidence of the following activities. And then it lists reasonable and prudence of any specific project, future recoverability of specific items or items of cost, and pre-approval of rate-making treatment. If, and that period, new sentence, if there is commission approval of the 2023 CPRE, this will not be dispositive evidence in these activities. So without asking for information, pertaining to any settlement, negotiation, or anything like that, can you clarify, what's meant or what you mean by the term dispositive? And Ms. Smith's answer starts on line 23 on page 34 of the transcript. Sure. Certainly, I can give the company's view of these provisions, and that is just simply stated. H talks about what the approval would not mean, and I talks about what the approval would mean. So H is that the approval would not mean, dispositive determinations of those three factors in subsection H, but approval would mean that what comes out of this docket is relevant to future proceedings. So relevant, not dispositive, is how I read those two provisions together. There's another question. Let's drill down on that some. As I understand dispositive, at least what it means definitive or seals the deal. The evidence is overwhelming. Something along those lines. Is that a fair assessment? Ms. Smith's answer, I think when I look at these provisions, this approval of the CPRE program is an important step on the continuum. We plan, we execute, we have various dockets that we bring before the commission, and then we place assets into service and come in for a rate case. So we all have all of these steps. So know that these steps are not singularly dispositive, but they are important milestones, and they are relevant, strike that, they're relevant to one another. Strike that was my words, not Ms. Smith's. So approval of the CPRA program would not be the end-all, be-all. We would still have to come in for Siting Act applications. For example, if a project triggered Siting Act approval, we still have to make our showings in rate cases, and we still, if the commission approves the CPRA program, the day after the order comes out, we are still subject to acting prudently, to managing the execution of the CPRA program, to make, well-informed and reasonable decisions for customers from the day the order comes out on throughout the process as these selected projects advance. Another question, okay, what I'm trying to be definitive about, what my understanding is of dispositive. It's not the same thing as persuasive or circumstantial evidence or terms like that. Is that a fair statement? Ms. Smith's answer, yes. I certainly leave it to council, but I think we're looking at this as more probative than dispositive in terms of, and Ms. Smith was interjected or interrupted on, I'm reading from page 36. The interruption starts on line 17 by Commissioner. Can I help you out a little bit? Can I ask a clarifying question? And I should say another commissioner was interrupted by a commissioner, not Ms. Smith, excuse me. The commissioner grants leave for the interruption, and the commissioner who interrupted asks, under these terms, would it be a fair statement that Duke could not show up at a rate case hearing and say, you approved this in the CPRE, therefore we get cost recovery with no further showing? And line 25 on page 36, Ms. Smith's answer is correct. Sorry for that painful reading of the transcript. I don't practice reading transcripts, but I did the best I could. I wanted to lay all that out is why I feel comfortable with the settlement agreement as presented by the parties, and I welcome any questions from my fellow commissioners. But with that, Mr. Chair and fellow commissioners, I would again move that the commission find that the settlement is in the public interest, grant the 2023 CPRE program application, and approve the settlement agreement.
Thank you, Vice Chair Williams. Any further discussion?
Chair Powers?
Commissioner Carol Williams.
Thank you. Chair Powers and fellow commissioners, I agree with the approval of the settlement as noted in Vice Chair Williams's motion, but I have a substitute motion that I'd like to make that has the same outcome but provides amplification by the commission. This motion would read, I move that the commission approve the settlement agreement supporting the 2023 competitive procurement of a renewable energy program. It's, and I quote, 2023 CPRE program, quotes closed, between Duke Energy's Carolina LLC and Duke Energy Progress LLC, also known as the Duke Companies, and the Office of Regulatory Staff, finding that the 2023 CPRE program, quote unquote, is consistent with the overall framework approved by this commission for the Duke Companies. The company's previously approved CPRE program is the framework that guides future RFPs or solicitations. I move that the commission find that in their 2023 CPRE program, quote unquote, the Duke Companies utilized their previously approved CPRE program, the process established pursuant to South Carolina Code Annotated Section 58-41-20E2 by order number 2024-141, and therefore the 2023 quote-unquote CPRE program is in the public interest. I further move that the commission find that the approval of the settlement agreement and any findings supporting the quote 2023 CPRE program unquote be limited To this case, at this time, the Commission retains the right to evaluate any product of the RFP or solicitation pursued as to its reasonableness and prudency in such future proceedings as may be appropriate. Such determination shall stand on its own merit of each expenditure and be considered independent of the approval of this, quote, 2023 CPRE program, unquote. My comment very simply is, I believe that this motion, while approving this settlement agreement, provides specificity to that settlement agreement. It's not contrary to the settlement agreement, but augments the understandings associated with the agreement. Thank you.
Thank you, Commissioner Williams. As to the substitute motion, is there any further discussion? Commissioner Belson.
Mr. Chairman, Commissioner, I respectfully disagree with the substitute motion and will be voting against the substitute motion. I think that the settlement agreement and the testimony elicited in the hearing are very clear. In construing a settlement agreement, I think the Commission, as sitting as a judicial or quasi-judicial body and subject to Code of Judicial Conduct and other rules, would construe the settlement agreement akin to a contract. I don't think that the terms of the settlement agreement are ambiguous, and any ambiguous contract should be given, the words of an unambiguous contract or settlement agreement should be given their plain and ordinary meaning. I think that the meaning of the settlement agreement is very clear, and if you can't get it from the settlement agreement, the testimony augments and certainly says that there's no predeterminations of citing, no predeterminations of cost recovery, and I don't think that anything further is needed to try to augment or supplement or add specificity to the settlement agreement. It's specific enough in my mind, and so I'm going to be supporting Commissioner or Vice Chair's motion and not supporting the substitute motion. Thank you.
Thank you, Commissioner Belson. Any further discussion?
Chair Powers.
Commissioner Thomas.
Thank you. I also believe it's in the public interest for us to approve the settlement agreement. However, the settlement agreement is in the words of the Duke companies and the ORS, and that's a good thing. But I further believe that the motion made by Commissioner Carol Lee Williams puts the approval in our words, and very importantly, in the context of the sworn testimony we heard at the hearing. For those reasons, I will be supporting your motion, Commissioner Carol Lee Williams. Thank you.
Thank you, Commissioner Thomas. Commissioner Caston.
Well, I was just ready to vote.
Okay. All right. Is there any further discussion?
Mr. Chair,
Vice Chair Williams.
Commissioner Williams, respectfully, will not support your motion. Similar to Commissioner Belzer, I think the record is so clear and sound that amplification is not needed, and for that reason, I respectfully decline to support your motion. Thank you.
Thank you, Vice Chair. Any further discussion? Hearing none, we'll proceed to a roll call vote on this particular case, beginning with, and this is as to the substitute motion, beginning with Carol Lee Williams.
Aye.
Commissioner Belser.
Nay.
Commissioner Caston.
Aye.
Commissioner Thomas.
Aye.
Commissioner Williams. Vice Chair Williams.
Thank you, sir. I respectfully vote no.
And I vote no. The motion fails. We will now go back to the original motion made by Vice Chair Williams. Is any further discussion as to the original motion? Hearing none, we'll proceed to a roll call vote, beginning with Vice Chair Williams.
I vote aye.
Commissioner Williams.
Respectfully and thoughtfully, no. And painfully, no.
Commissioner Belser.
Aye.
Commissioner Caston.
No.
Commissioner Thomas.
No.
And I vote aye. Again, we will have a tie. The motion fails. Let's move to item number 3.
Item number 3 is in dockets numbered 2025-57E and 2025-59E. This is a request from Central Electric Power Cooperative Incorporated for confidential treatment of Exhibit A in its application, and a request from Santee Cooper to consolidate to consolidate these two dockets for hearing purposes.
Thank you, Mr. Scarborough. As to item number 3, is there a motion?
Mr. Chairman,
Commissioner Belcher.
on February 12th, 2025, Central Electric Power Cooperative Incorporated filed an application for a certificate of environmental compatibility and public convenience and necessity, which is designated as docket number 2025-59-E. Central's application seeks authorization pursuant to the South Carolina Utility Facility Siting and Environmental Protection Act to construct 2 single-circuit 230 kilovolt feeder transmission lines and associated facilities originating at the proposed Cypress switching station and terminating at substations that have been designated as MNK substations. The MNK substations will be owned by a Central member, Berkeley Electric Cooperative Incorporated, to provide service to Berkeley's customer and member in the Mount Holly Industrial Park in Berkeley County, South Carolina. As part of Central's application, specifically in paragraphs 8 and 9, Central asserts that Exhibit A should be deemed confidential and protected from public disclosure in accordance with Order Numbers 2005-226 and 2020-490. Central provided a confidential version of Exhibit A to the Commission and advises the confidential version of Exhibit A contains commercially sensitive and proprietary information of a highly competitive nature. Central also filed a redacted version of Exhibit A to protect disclosure of confidential information while making available for public viewing non-protected information. Central requests a protective order barring disclosure of the confidential exhibit attached to its application and that the Commission allow the unredacted version of Exhibit A to be filed under seal and barring its disclosure under the Freedom of Information Act, South Carolina Code Annotated Sections 30-40-10 exec, South Carolina Annotated Regs 104-804, subsection S1, and any other applicable provision of law. I move that the Commission find that 1. Exhibit A to Central's application contains commercially sensitive and proprietary information of a highly competitive nature and that release of information could adversely impact the Berkeley Electric Cooperative's customer and member in the Mount Holly Industrial Park. And 2, that Exhibit A to Central's application should be designated as confidential and protected from public disclosure pursuant to South Carolina Code Annotated Section 30-4-40A of the Freedom of Information Act and South Carolina Code Annotated Regulations 103-804, subsection S1. Therefore, I move that the Commission grant the request of Central Electric Power Cooperative Incorporated for a protective order and confidential treatment of Exhibit A to its application. Additionally, these proposed transmission facilities will be owned and operated by Central, are planned to connect to the proposed major utility facilities identified in the application filed by the South Carolina Public Service Authority, also referred to as Santee Cooper, and docket number 2025-57-E. Like the proposed Central facilities at issue in Central's application and docket number 2025-59-E, major utility facilities at issue in Santee Cooper's application will be built to serve a new industrial load from a current industrial customer of Berkeley Electric Cooperative Incorporated, which is a member cooperative of Central. Both this application and Central's application concern facilities being built to serve the same retail customer on the same site and are part of the same economic development project. Santee Cooper requests that the Commission consolidate docket numbers 2025-57-E and 2025-59-E for the purpose of a hearing. Santee Cooper asserts that both actions involve a common question of law or fact pending before the Commission. Santee Cooper also states that consolidation of the two proceedings will serve the interest of judicial economy by ensuring consistent adjudication of a common set of facts involving a single project and will avoid duplicative pleadings and testimony. Central also requests that docket numbers 2025-57E and 2025-59E be consolidated for hearing and states that approval of both applications is necessary for Central and Santee Cooper to provide service to meet the needs of the customer. Commission Regulation 103-840 provides that the Commission may, upon its own motion or upon a motion by any party, order two or more proceedings involving a similar question of law or fact to be consolidated for hearing where rights of the parties or the public interest will not be prejudiced by such procedure. I move that the Commission find that docket numbers 2025-57-E and 2025-59-E involve similar questions of law and fact concerning connecting projects, and that there is no prejudice to the public interest or the parties of record. Therefore, I move that docket numbers 2024-57-E and 2025-59-E be consolidated for the purpose of hearing. So move.
Thank you, Commissioner Belser. Having heard the motion by Commissioner Belser, is any further discussion?
Chair Powers?
Commissioner Williams?
I think that at the very end of Commissioner Belzer's motion, I heard a reference to 2024-57-E when I believe that the docket's 2025.
Thank you, Commissioner. If I certainly misstated that, the correct docket number, both of them are 2025. They were both filed recently. Thank you.
Thank you, Commissioner Williams and Commissioner Belser. Is any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Those opposed by no, the ayes have it. The motion carries.
Item number 4 has been removed from the agenda. So item number 5 appears in docket number 2024-303E. This item involves a request for approval of a comment and response schedule proposed by Duke Energy Carolinas LLC and Duke Energy Progress LLC.
As to item number 5, as presented by Mr. Scarborough, is there a motion?
Chair Powers, I'd like to make a motion.
Commissioner Caston?
Thank you. I move that the Commission approve the schedule proposed in the Duke Company's letter dated February 10th, 2025. Schedule for comments and responses shall be as follows. February 28th, 2025, initial comments from ORS and interveners. March 17th, 2025, comments by the companies or any other party in response to initial comments, and March 31st, 2025, reply comments by any party to responsive comments. Duke companies have presented that all parties to this docket do not object to this schedule. I'd further note that there has been no objection filed by any party of record. That's my motion.
Thank you, Commissioner Caston. Having heard the motion by Commissioner Caston, is there any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Those opposed by no, the ayes have it. The motion carries.
Mr. Chairman,
Commissioner
I have
Belser.
a procedural question. With regard to utilities agenda item number 2 on this agenda, there's no prevailing side, so I can't move for reconsideration for a later meeting. I'm not sure how we will proceed because we have not disposed of this matter.
Commissioner Belser, I am inclined at this point to take about a 15-minute break and let me review some things, and then let's come back and let's not adjourn at this time, but we'll just recess for 15 minutes.
Thank you.
We're in recess. We are back on the record as to our special business meeting. I'm going to pass the gavel to the vice chair. And Vice Chair, I would like to make a motion if I could.
Thank you, Chairman Powers. Chairman Powers is recognized for a motion.
Thank you. I would make a motion that as to item number 2, that it be carried over to a future hearing date, or rather a business meeting date, that with nothing specific, but just at a future date. Give a chance to give everyone to really consider this and give it proper weight. And was so moved.
Fellow Commissioners, hearing Chairman Powers' motion, is there any discussion? All right, hearing none, I will call a roll call vote, starting with Chairman Powers.
Aye.
Commissioner Thomas,
Aye.
Commissioner Caston,
Aye.
Commissioner Belzer,
Aye.
Commissioner Williams,
Aye.
and Vice Chair Williams votes aye. The ayes have it, the motion carries.
Thank you.
Mr. Chairman and Commissioners, this concludes all business noticed before the commission today.
Thank you very much, Mr. Scarborough. I urge everyone to thank everybody for joining us. I urge you to be with the weather supposedly heading our way to please use extra caution the next few days and please stay warm. We are adjourned.